friends, today I'll be discussing about international law. I'll discuss its meaning and development under international law and theories under international law. First, as usual, I'll go forward with the introduction, then meaning of international law, development of international law, whether international law is called law in itself, then theories of international law, and then I'll be concluding my lecture. The whole world couldn't be one big family, and hence it split into various countries. International law never says that a country should not be sovereign. Its sovereignty should not become a threat to the other country's sovereignty. Law of nations and international law have been used synonymously. In its Latin usage, international law meant jus gentium, meaning the law of the people. Jeremy Bentham was the first one to use the term international law in 1780. It is a translation of the phrase "juris inter gentes", which was first used by Richard Zouch in 1650. It is noteworthy to mention that in its earlier usage, the law was restricted to private law and not public law. To combat situations such as war, law of seas, and other issues related to international law, a need was felt that it should be done through peaceful means such as mediation, conciliation, and diplomacy, and hence they became the subjects of international law. Let me illustrate regarding international law. Let us suppose that there are two countries, Bharata and Lanka. River Ganga flows from Bharata to Lanka. Bharata has set up many industries on the banks of the river Ganga. Bharata has been releasing effluents into water. Lanka has experienced crop failure, endangerment of aquatic animals, and water pollution has become a health hazard. Lankan citizens are furious and raise a protest. You are harming our environment and violating our right to clean water. Go back, Bharata. Bharata responds, "It's our river, our territory. We can do whatever we want." Bharata puts Lanka into dilemma. Lanka decides whether they should go to war or are there any binding rules that the ancestors of Bharata and Lanka created. International law provides for ahimsa and equitable distribution of resources. What are the mechanisms available? Mediation, conciliation, and negotiation. And the body which resolves the issue is Antarashtriya Nyayalaya. So, what happens when we study international law? How should states interact responsibly? How sovereignty is balanced with global responsibility? How could the issues such as water pollution and issues such as war can be resolved through a unified framework addressing the issue? These are the questions which international law will answer. If one studies international law, they can deal with questions raised in this illustration. Let us get deeper into the lecture. Oppenheim defines international law as the body of customary and conventional rules which are legally binding on the civilized states in their intercourse with each other. So, if you break down this definition, you can see that there are customs and conventions which a country will have agreed with the other country in their dialogue or intercourse, and that will become binding on both the countries. Let us understand international law through G.K. Starr's definition. It is The body of law, which is composed for its greatest part the principles and rules of conduct which states feel themselves bound to observe and therefore do commonly observe in their relationships, which include rules of law relating to functioning of international institutions, organizations. Then certain rules of law relating to individuals and non-state actors. If you break down this definition, you will see that there will be certain principles and rule of conduct which each country will have adopted and the other country will have to be bound and it has to observe these principles. And let me tell you, these are rules relating to international organizations. Because of war and other situations, there was a need which was felt that there should be an international organization which can address these issues. And thus, that led to establishment of institutions such as UN, ILO, and other international organizations. So it also deals with rules of law relating to these institutions. And also it deals with situations such as state and non-state actors. I'll be explaining about state and non-state actors in my next lecture. But let me break down. A state is one which has a population, definite territory, and has government and has people who are willing to follow the government and a lot of other features. But these are the primary features that have to be present to a state to be called a state and not a non state actor. The two of our greatest epic, Ramayana and Mahabharata, have been the epics which have discussed international law in depth. There are rules of treaties, diplomatic immunity, international humanitarian law, which were applied and which stated that even the prisoners of war could not be executed. These rules have been found in even Roman law and was followed even in the 16th and the 17th century. Hugo Grotius in the 17th century played an important role in developing the international law and he was called as the father of international law. He was a poet, philosopher, mathematician, theologian, jurist, and a diplomat. He stated that law of nature was independent apart from customs and treaties. In the 18th and 19th century, there were a lot of inventions, transportation, and other issues that cropped up, and these became an issue for adjudication by international arbitral tribunals and many more. In 20th century, many international organizations were established. The Permanent Court of Arbitration was established by Hague Conference of 1899 and 1907. The League of Nations was established in 1990. In 1921, an international judicial body known as the Permanent Court of International Justice was set up. In the aftermath, it led to the establishment of UNO in 1945. International Court of Justice preceded Permanent Court of International Justice in 1946. In 1947, International Law Commission was established, which became a pioneer who codified and developed the international law. It assisted the International Committee in codifying the law related to international laws such as law of disease, war, and treatment of refugees, treatment of things like asylum and other things. Present-day international law consists primarily of lawmaking treaties and international customs. Lawmaking treaties have been adopted in various fields such as international humanitarian law, human rights, intellectual property rights, law of disease, space activities, and other terminologies. Let me tell you here, it, it is not exhaustive. There are a lot of areas that have been dealt under the concept known as the international law. The growth of international criminal law has been exponential in 17th and 21st century. Now, if a state head or a political party or a military head, bureaucrat or any other person commits war, he can be prosecuted and punished if found guilty. Answer the question, is international law law? Austin categorized laws into laws properly so called and laws not properly so called, and international law fell in the latter category. He considered international law to be full of sentiments and opinions. And to govern these laws, there was no single authority as per the realists. That is to say that to coerce and make the people obey the rules and regulations, it did not emanate from a single authority. It was moreover customs and usages which the people had adopted amongst themselves. Without formal legislative authority, a system of law was in force. That is what the historical school of law originators state. Savini stated that the spirit of the people is the one which was followed, and hence international law was also a spirit of the people. But the point is, the people, are they confined to one particular country or are they global citizens? It was also observed that international law was always followed without any compulsion. If you see Ramayana and Mahabharata, you will see that diplomatic immunity and situations such as humanitarian laws were followed without any compulsion. Certain countries regard international law as the law of the land itself. Let us discuss the theories of international law. The first one is positive theory. The positivists believe that law was not divine and law was man made. Customs and treaties were considered to be two major sources of international law. The extreme positivists denied the existence of law of nature, which stated that law was of a divine origin. Moderate positivists admit that there was existence of law of nature, but keep it very minimal. And they stated that law derives from the subjective will of the state and that there was no role for divinity or saying that the law was divine in nature. The natural theorists, however, differ from positive theorists. The natural theorists believe that law had a divine origin and had a divine sanction. There were two classifications, just natural and just gentium. Just natural meant natural law of nations, and just gentium meant voluntary law of nations. The natural law of nations is based on reason. The voluntary law is based on the will, that is, the consent of the states. Grotius, who was one of the main proponents of natural theorists stated that there is an essential morality and divine justification for the nature of things and for things around us, and the nations, as well as the men, ought to be governed by the universal principle. The third theory is the Grotian theory, which is a midway between the naturalists and the positivists. Vattel, who was a Grotian, stated that the equality of states concept was a part of the natural law itself. He was of the opinion that the states were made up of men and all men were by nature free and equal. It would follow that sovereign states should be regarded as free persons living together in a state of nature. Thus, I would like to conclude by stating that international law was the rules and regulations which were commonly adopted by the states in their common discourse. International law was codified by the International Law Commission after the emergence of League of Nations, UN, and other international organizations. The positivists believed that law emanated from the sovereign, and they considered that international law was filled with opinion and sentiments, and it did not emanate from a sovereign. The historical school, however, differed that without the existence of a common figure or a single authority, the laws were in force, and history was the proof of it. And Sivani stated that Bob chased, meaning the spirit of the people. The people were the ones who ultimately decided and consented to the law, and international law was no different. Thank you for listening to my lecture on international law. Do let me know in the comments what is international law and tell me what are the theories of international law in your own words.